So, let's talk about pregnancy and relocation and the right to travel. On behalf of the Marks Law Firm LLC, posted in paternity, relocation, and child custody on Wednesday, November 27th of 2013. A case involving an Olympic skier, Bodie Miller, has received a great deal of media attention because it touches on some very sensitive and personal rights. It seems that Bodie Miller met Sarah McKenna through an online dating website. Their brief relationship resulted in pregnancy. Miller wanted McKenna to terminate, but she decided to have the baby. At the same time, Miller got married to his girlfriend. So it sounds like Miller was cheating on his girlfriend and got another woman pregnant. So Miller got married to his girlfriend. As the pregnancy proceeded, I'm making allegations, by the way, but that's what it sounds like to me. Because at the same time that she decided to have the baby, Miller got married to his girlfriend. So, yeah. As the pregnancy proceeded, Miller decided to file a paternity suit in California, and McKenna chose to move to New York to attend Columbia University. Days after giving birth, McKenna filed her own paternity suit in New York. Under the Uniform Child Custody Jurisdiction and Enforcement Act, or UCCJEA, the only state with jurisdiction over the child was New York, since the child had resided in New York since birth. But a strange thing happened. The New York judge hearing the case decided that California also had jurisdiction, even though the child had never resided in California. Perhaps the first case to find fetal jurisdiction under the UCCJEA. The judge further added that McKenna was shocked by moving to New York, so he sent the case to California to proceed on the petition for paternity filed by Miller, a petition for custody of a fetus at the time he filed, something the law does not recognize. And just when you think the case cannot get stranger, the California court awarded Miller custody and orders McKenna to turn over the child. McKenna filed an appeal in New York, and the New York appellate court overturned the judge's mistaken opinion. It made clear that only New York had jurisdiction over the child. The ruling rendered void of all actions in California. However, California has not fully complied and still deciding whether to keep jurisdiction. It seems certain that California will soon acknowledge New York as the only state with jurisdiction and order the return of the child to McKenna, and New York will hear the merits of the paternity suit. This case has raised several important issues, for some simple, but some very difficult to resolve. First, adults have a constitutional right to travel, according to the Supreme Court. A state cannot infringe on that right unless the other countervailing state interest at stake. Cannot infringe on that right unless another countervailing state interest is at stake. In this case, the best interest of the child whom the court has jurisdiction, because a court cannot adjudicate custody of an unborn fetus, and a court cannot discriminate against women because of pregnancy. No law prohibits an unmarried pregnant woman from moving out of the state where the father resides to another state, for whatever reason. Ironically, had Miller and McKenna been married and Miller filed for divorce prior to the move, the court could have prevented the move to preserve the status quo. Second, paternity suits usually do not involve forum shopping because of UCCJEA, which gives the state in which the child has resided for at least 6 consecutive months preceding the petition for paternity priority as the home state of the child. Third, the disparity between children born of wedlock and children born out of wedlock gives mothers a jurisdictional advantage. Suppose the Miller McKenna matter wanted the child and the relationship, suppose in the Miller McKenna matter, Miller wanted the child and the relationship, but McKenna chose to cut ties with Miller and relocate with no concern for his participation in the child's life. In this scenario, no law would have prevented McKenna from relocating across the country, filing for custody after birth of the child. Miller would have to go to New York to defend and face a tough custody battle that might make it highly unlikely he would be able to bring mom and child back to California, putting him in the position of choosing where to reside, which may involve a career choice and custodial time with the parent or with his child. Fourth, relocation statutes in general impose the opposite burden on parents who divorce and subsequently want to relocate. The courts genuinely frown upon a relocation that will significantly impair the frequent and meaningful contact of both parents with the child. If one parent remarries and wants to move away, courts may decide to give the non-relocating parent custody. The courts may take a more favorable stance to the relocation if the relocating parent is the principal financial support and the relocation is directly related to maintaining or improving employment. In general, courts take the view that the child could have close and continuing contact with both parents, which means keeping the parents close, particularly if neither has the financial means to pay for transporting the child back and forth across the country. Courts would prefer parties work out relocation issues on their own, but if asked to decide, the best interest factors of the child stand more often than not. Keeps custodial best interest factors of the child standard more often than not keeps a custodial parent close to a non-custodial parent, which many see as a bias against women and mobility. About the right to travel, as noted, courts have rejected the notion of a right to travel trumping relocation. In this situation, the best interest of the child standard governs, and courts evaluate every purpose or proposed move in that context. Because we live in an increasingly mobile society where women are co-equal earners with men, the problems of relocation never have been so acute. Women are significant parents and earners, and so are men. Eventually, the courts have to figure out a more sophisticated method of handling the situations, particularly in difficult economic situations. So this article is very insightful because it literally talks about everything that is wrong with relocation. And it shows a clear bias that in divorces, mothers are more inclined to be held to higher standards than women that weren't married. So, will you make that make sense, guys?